Imagine waking up every day and believing, seeing that who you are is not valid because state has not approved it. That means your identity will be decided not by you, not by society, not your family, but by the law. But the deeper question here is, can the state actually define the entity, the dignity associated with a person? Does state have this power? And the question arises here that why are we discussing this? We are discussing this because of a bill in question which has brought riot across the nation because it questions the individuality, the identity, until and unless state puts a mark on it. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to talk about the Transgender Bill of 2026, which is an amendment bill. But the change here is so big in the details which is given that it is going to change all the purpose of the bill and the NALSA judgment that came. So let us try to understand that what has happened and what are the layers around it. Starting with understanding that what exactly has unfolded. So let us begin with 2014. So in 2014, NALSA judgment came in, that was NALSA versus Union of India, where there was clear recognition of the third gender. And it clearly talked about how self-identification is a fundamental right as well. As a consequence, we saw in 2019 came the transgender bill by the government. Now, the bill we are talking about is the same bill that is being proposed to be amended in 2026, and that is why we are seeing these protests, these marches going on across the country. So what is so problematic that 2019 bill now it is being amended in 2026 and it is causing problem. So the core issue here is that the right that was given in the NALSA judgment of self-identification, that is being taken away in terms of gender identity. As per the judgment and as per the act as well, self-identification, that means transgender people could identify as third gender on their own, they could declare it on their own, identify on their own. That particular right is being taken away in this. And that is why there is a triggered debate that judicial recognition of rights and the debate around that exists, that has taken up. And the key tension that is existing here is about key autonomy, that how our identity should be told by us, identified by us, and how state can regulate it. Is there any scope or where does it stand? So the key tension exists between the personal individual autonomy and the state regulation here. Now to understand this better, let us move one by one, starting with the NALSA judgment itself. So when we are talking about the NALSA judgment of 2014, this Supreme Court judgment clearly recognized transgender as a third gender, and they were the one who gave this as a right to self-identification. That means there was no need for medical or any surgical proof at all. A person could identify themselves as third gender without any medical, surgical state proof at all. And Supreme Court went ahead and said this is associated with person's fundamental rights, where Article 14 talks about equality before law, Article 19(1)(a) talks about freedom of expression, and most importantly Article 21, which talks about right to dignity and privacy. Now once this judgment came out, a key doctrine took a establishment because of this, that constitutional morality stands over the social morality which has been set up by society, and the rights of transgender as well as third gender are to be recognized. Now based on this very judgment, we saw this Transgender Persons Act of 2019. Now this was the legislation which was brought in to give the judgment a law framework so that it can be implemented. Now in this particular act, what did we saw as key provisions? We saw that there was a legal recognition of transgender person And there was also a clause which talked about anti-discrimination in terms of education, employment and healthcare. As well as there were welfare obligations that were put on the government. Furthermore, this was the very act which talked about certification process. That means a certificate would be given by district magistrate, and if there will be any change to male to female, that would require proof, that would be a medical proof. Now, because of this certification process itself, this 2019 Act was also criticized a lot, because when we were talking about the NALSA principle, we have just seen it talked about no medical proof. Furthermore, it not only diluted the principle established by the Supreme Court judgment, it also introduced a bureaucratic gatekeeping. That means district magistrate was the one who would finalize the certification. So this act, even though it was hailed as the first on the lookout on to help, on to recognize the third gender, but at the same time it had certain limitations. It had certain compromises, especially when we are talking about rights as well as regulation. A community which has seen limited rights for the longest time, they were getting some sort of enablement, but that was also limited because of regulation. Now comes the 2026 Amendment Bill. Now the question is, what exactly is changing? So the main thing that we need to understand here, that this particular amendment bill is deleting the self-perceived gender identity part. And the amendment is proposing that state will have a defined criteria for the identity, for which there will be either a medical or psychological verification, and there will be proper screening mechanisms. Now the problem here is that this amendment not only dilutes, it takes away, it deletes the NALSA principle altogether, and where a self-perceived gender identity is something very much related to dignity of the individual, autonomy of that individual, that will also be compromised because of state regulation right here. Also, when we are talking about this change, this is not just a random change, this is not a procedural change, this marks a structural shift when we are talking about a certain community, because this takes the Transgender Persons Act, which had self-declaration, to state certification, which was right-based, based on 2014 and 2019, to administrative control. Now what identity, which was a personal right, which will become a regulated category. And that is the core concern that we have been talking about. Now let us try to look at it from all the angles, starting with the pros and cons. So there are certain arguments in favor of the amendment that is being made, such as that welfare schemes will be able to deliver and better target. There are arguments that the misuse that is happening because of reservations and legal entitlements present to the third gender, that will also reduce, and this will also give administrative clarity. But the problem here is, as much as these arguments might make sense, the consequences will make equally sense or more. Because when we are talking about bodily autonomy, which is a very important part of Article 21, which talks about right to life, which talks about right to dignity, which talks about right to privacy, this bodily autonomy will be violated. This directly contradicts a Supreme Court judgment, which might create a friction not just between legislature and judiciary, but it also violates the spirit of judiciary in which this judgment was given. Apart from that, this particular amendment directly brings the risk of medicalization of identity and bureaucratic harassment, which is pretty common in our country. Not concentrated towards the gender, but then this community has been vulnerable, has been weak, and they would be more vulnerable to the risks that we are talking about. And a bigger risk that comes to the LGBTQA community is that there might be exclusion of non-binary people who do not identify as a certain gender, and gender fluid people as well. Now, this all will amount gradually to a bigger constitutional challenge, and this will again go for judicial review. This will again be presented in front of judiciary, because as I said, the consequences, the criticism way higher as compared to the arguments which are in favor as of now. Furthermore, when we are talking about dimension itself, this is not the place where we talk about only pros and cons. We also have to look into dimensions such as constitutional dimension, because when we are talking about NALSA principle that was given by Supreme Court, legislature has gradually not only diluted it but deleted it. So the issue that comes out here, can parliament actually dilute fundamental rights? If you look at from the sociological dimension, India has traditionally transgender communities, but at present what you will see with law, that law does not has any space or very limited space for any sort of fluid identities. And if you look at the global dimension, you will also find that when we are seeing global models moving towards self-ID model, India is lagging behind. India is moving probably in the reverse direction in the name of administration. What are the other dimensions that you think that we should talk about? Let me know in the comment section. Also, let me know your thoughts in the comment section, that what do you think are the arguments in favor from your end or the criticisms from your end, so that we can have a actual conversation about it. Once we have talked about this issue at hand in detail, now let us talk about that what exactly can be done. As of now, it looks like that self-identification, which is a core right, it should definitely be retained. Furthermore, we need to bring better safeguards against misuse. If we want to bring amendments, we need to be prepared for the consequences, criticism, and put in better safeguards. If we want that there are verification processes to be put in place, they should be used in only extreme situations and mostly non-invasive methods, if at all they are needed. And the most important factor, that the alignment should be with the NALSA judgment and our fundamental rights. Because if we want to ensure state regulation, it needs to come with administrative sensitization, it needs to come with community participation and the community's will as well. Now that was all from my side. I'll be leaving you here with a prelims practice question on this very topic. You can put down your answers in the comment section. Thank you so much.